The debate over stand your ground laws raises fundamental questions about self-defense in the United States of America. In recent years, we've seen a dramatic increase in laws expanding the situation in which a person can legally use deadly force in response to a perceived threat. Florida passed the first of this new wave of stand your ground laws in 2005. Prior to 2005, Florida law held that a person outside his home could not use deadly force and then claim self-defense if the person could have safely avoided the confrontation. This, quote, duty of safe retreat, close quote, sought to prevent public disputes from escalating into violence. But the gun lobby pushed to change Florida's law so people could shoot someone who threatened them without first trying to avoid a confrontation. Florida wasn't the first state to adopt this stand your ground principle, but Florida's 2005 law expanded the principle in several dramatic new ways. First, the law grants criminal and civil immunity for uses of deadly force in stand your ground situations. Second, it replaces a defendant's burden of proving reasonableness with a presumption of reasonableness when the defendant shoots anyone who intrudes upon his home, porch, or vehicle. Third, it even allows the use of deadly force when a threat is not imminent. The gun lobby wanted to spread Florida's law across the nation. So the National Rifle Association went to ALEC, the American Legislative Exchange Council, and asked for their help. Now, ALEC is an organization that brings corporate lobbyists and state legislators together for conferences. They draft model bills, and then they work to get them enacted. In 2005, ALEC adopted model legislation that was nearly identical to Florida's law. They then began promoting it in state houses across the country. Within a year, 13 more states passed similar laws. Today, 25 states, not counting Florida, have passed a law based in whole or in part on the ALEC model. ALEC called the enactment of these laws one of, quote, ALEC's successes, close quote. CNN described ALEC as being, quote, behind the spread of stand your ground laws, close quote. The Wall Street Journal said ALEC was, quote, a key advocate for them. Now that ALEC-style stand your ground laws are in effect for over half of the United States, we're seeing their national impact when it comes to public safety and civil rights. This is what we will learn from our witnesses today. These stand your ground laws have led to increases in homicides and firearm injuries, including 600 additional homicides per year, with no deterrent effect on crimes like robbery or assault. This point was made in several studies, including recent research from Texas A&M University. Second, these stand your ground laws have allowed shooters to walk free in shocking situations. Shootouts between rival drug gangs, drug deals gone bad, and more. This point will be made effectively by the testimony of David Laban, President and CEO of the Association of Prosecuting Attorneys. Third, in some devastating cases, the laws have emboldened those who carry guns to initiate confrontations which have ended up killing unarmed children. The testimonies of Sabrina Fulton and Lucy McBath about the devastating losses of their sons make that point more effectively than I ever could. Finally, these stand your ground laws increase racial disparity in our criminal justice system. One study found that in stand your ground states, nearly 17% of homicides involving white shooters and black victims were ruled justified, compared to 1% of homicides with black shooters and white victims. At my request, the Congressional Research Service analyzed FBI data on justifiable homicide before and after the 2005 wave of stand your ground laws and found that racial disparities clearly increased. I'll be putting the CRS memo in the record. It is clearly time for stand your ground laws to be carefully reviewed and reconsidered. Whatever the motivation behind them, it's clear these laws often go too far in encouraging confrontations that escalate into deadly violence. They are resulting in unnecessary tragedies, and they are diminishing accountability under our justice system. I'm pleased that the efforts to reconsider these laws are now underway. Earlier this month, one of the legislators who drafted Florida's law joined with some of its chief opponents in a bipartisan effort to change the law. They've been passed in a state Senate committee in Florida. There's more that needs to be done, but we seem to be moving past the question of whether stand your ground laws should be fixed. Now we should be looking at the best way to fix them. I urge other states that have stand your ground laws to revisit them as well. To the extent that stand your ground laws were passed based on the ALEC model, I would note that few who are connected with ALEC appear wedded to that model today. I reached out to every company and organization that has been publicly listed as a member or sponsor of ALEC since 2005, simply asking them, do you support the Stand Your Ground bill? 140 of them responded. Only one said yes. Even ALEC, through a Connecticut state representative and its chairman, Mr. Piscopo, made a statement to the press that ALEC no longer has a policy on stand your ground laws. It is also important that Congress review stand your ground law because of the way proposed federal legislation implicates those laws. Just this past April, 57 senators voted for a gun lobby amendment that would allow a person who receives a concealed carry permit in one state to carry his gun in every state, even if the person would be disqualified from getting a permit in the other states because of criminal convictions, inadequate training, or other factors. Congress should think carefully about how proposals like this would mix with stand your ground laws.